The Washington Post is now reporting that former President Trump is rushing to assemble a team of veteran lawyers to defend him from potential criminal exposure after classified documents were recovered from his Florida home, but he keeps getting rejected. According to court documents, we know of two high-profile lawyers representing Trump, Evan O'Connor, who was Steve Bannon's trial lawyer, and Jim Trusty, who was a former federal prosecutor. Trump and his allies have put forth a number of arguments following the search. Let's talk more about those arguments and how effective they might be. With us, CNN senior legal analyst and former federal prosecutor Elie Honig. Elie, their defense has evolved, right? But there have been some distinct themes, and let's discuss how valid they may or may not be based on the evidence that we have. Defense number one, they've argued all these documents had been declassified.
Yeah, so let's start with what we know, John. For sure, when the FBI went into Mar-a-Lago, they seized boxes that were marked with containing confidential and classified documents, up to and including TS-SCI documents, which is the highest level of classification. Now, legally, constitutionally, the president has extremely broad, arguably unlimited power to declassify documents at his will. Yes, there are rules, regulations, that kind of thing, but I think the better constitutional argument is that it's up to the president. The question here, though, is did he actually exercise that constitutional power to declassify while he was in office? Now, I've seen no convincing evidence that he did. You would expect there to be some sort of paper trail, and in fact, you cracked the case to an extent the other day when John Bolton, the former national security advisor, told you this: there was no standing order. I was not briefed on anything like that. I never heard it. I never saw it in operation, never knew anything about it. I just think it's a complete fiction. And John, more to the big point here, the three crimes that DOJ alleged in the documents that got at the search warrant, none of them have anything to do with whether the documents are classified or declassified. Maybe they were anticipating this argument. So it doesn't really matter when you're looking at those specific crimes.
So another defense that Trump and his allies have put forward is, well, the FBI could have asked nicely.
Yeah, that one does not stand up. First of all, calling this a seizure, saying they didn't need to seize anything, they broke in, saying this was a raid, that is nonsense, because we know that this search warrant was taken to and approved by a federal judge. We've seen the documents. He signed the forms. These are the standard forms. Donald Trump will have a chance to challenge this if there comes a day when he's charged. The way it would work, DOJ, if they seek an indictment, then Donald Trump gets the paperwork. He can go to court and say, this search was done in a way that violates my rights. But if we look at the facts here, the timeline, this notion that they could have had it if they just asked nicely really does not measure up. Back in January, National Archives, they asked nicely. They got some of the boxes, not all. May and June, DOJ asked nicely. They serve a subpoena. They get some more of the documents, but still not all. And finally, in August, they executed the search warrant. So this notion that, well, they just had to ask, that really doesn't stand up either.
All right, I'm going to try to articulate this other defense the best as I understand it, because it's a little hard.
Yeah.
Somehow he's arguing that the documents taken were covered by either executive or attorney-client privilege.
This one's really a red herring. Executive privilege only applies to certain communications between the president and top advisors, not to criminal-related communications. Attorney-client privilege is just out of left field. That would only apply between Trump and his attorney. But the real bottom line is, even if those arguments apply, I don't think they do, you don't get to take them home with you. It doesn't mean you personally possess those documents.
And there's this sort of fourth area that they are not leaning into, Elie, but might matter here.
Yeah, so everyone is sort of focused on Donald Trump's defenses. I understand why. But let's not miss the sort of important first point. In any criminal prosecution, DOJ has the burden of proving beyond a reasonable doubt. And the key issue is going to be Donald Trump's knowledge and intent. Did he know what was in those boxes? And did he have the criminal intent required by the various statutes to break the law? A couple of important things on that point. We learned yesterday, reporting from Maggie Haberman, New York Times, is that Donald Trump had said something like, they're mine. Those boxes are mine.
They're not theirs, they're mine.
Right. That would go to knowledge and intent. And importantly, we now know that DOJ has spoken with two top White House lawyers, Pat Cipollone and Pat Philbin. I'd be asking them questions that go to knowledge and intent. Did Donald Trump know what was in those boxes? Did he know about them being sent down to Mar-a-Lago? That could be key evidence for the prosecution's case.
Yeah, this new reporting from Maggie, there are a few sentences in there that go directly to this, may be very important going forward.
Yeah.
Could be part of that affidavit we may or may not ever see.
Exactly.
Elie Honig, thank you very much for that.